The way I shall proceed with quantum, if I may, is first set out the common ground, then our analysis, then a particular authority on which we rely, which is Parker, and then end with some comments on the authorities upon which the defendant relies. One point that I think should be made, and I understand this is common ground, is that we accept that this case is governed by common law principles as to damages, because of course the regulations could not authorise detention in contravention.
Why doesn't Lumber apply?
So we say Lumber does apply, and that's our submission. But we say that there's a misunderstanding of where Lumber leads. So we accept, and this is Lumber, that there is a burden on the Secretary of State once liability has been established to show that but for the illegality, the defendant could and would have detained in any event. Where the parties differ in this case, as my Lord Justice Hickinbottom identified, is the proper counterfactual. Could I start by doing this? I'm sorry, my moment of reflection, because I was going to deal with this when dealing with liability, but I would still like to go back to the reasons why the deputy judge said there was illegality, because this is very important. What was the illegality? Because that determines the counterfactual. So could I ask you to turn back to the judgment? And it's paragraph 62 of the judgment. And it's about 9 lines from the bottom. The deputy judge says, the absence of information about the individual conduct and circumstances left her, in my judgment, with material reasons which were not legally adequate to justify the continuing detention. The stage 2 decision was based upon what was known about the claimant, but is not, in my judgment, been shown to meet the standard of individualised proportionality and necessity in all the circumstances. So if we unpack that very concise statement, there are 3 bases on which period 2 was unlawful. And I'm going to this because it determines the proper counterfactual. First, there's not legally adequate material to justify the continuing detention. Second, not legally adequate reasons to justify the continuing detention. So it's not just about delay, it's about can the Secretary of State justify the detention. And third, he finds the detention is unnecessary, and this is an attack on delay. So, for example, no reason has been provided why the PSR has not been urgently obtained. But it's helpful to think about what would have happened in period 2 if the claimant had gone to court and made a habeas corpus application at some point during period 2. And the Secretary of State would not have had adequate material and reasons to satisfy the court that he was properly exercised. Because the Secretary of State, and this goes back to all our submissions yesterday, because of Article 27.2. So on the maximalist view, because the Secretary of State couldn't detain at all on the basis of previous criminal conviction, title, and length of sentence, and on the minimalist view.
But what would have happened?
I'm sorry.
On a habeas corpus?
Release.
Is that you'd have applied for habeas corpus, and presumably the Secretary of State then would have said, we better get some evidence. Got the OASIS assessment. OASIS assessment says risk of harm
Well,
based on the offence.
my lord, we actually say that the proper course for a court would have been to say, for example, the Secretary of State, if the deputy judge is right, the proper course for a court would be to say you've had enough time. And you just can't justify, you, the Secretary of State, can't justify this detention, you're going to have to release.
Why are you accepting that the judge was right about stage 3?
My lord, so the position changes in stage 3 not only because there's more information, but by that point there's been a decision to deport and a certification. So we're in a completely different setting where before the judicial review
On your
claim is
view
issued,
of the matter, there shouldn't have been a decision to deport either.
my lord, no, because the decision to deport, by the time the decision to deport is taken, there is an analysis about offending risk. There is an analysis there. Obviously, it ended up being found that Secretary of State...
So your point is that although there was sufficient information to deport, there was not sufficient information to detain.
Well, there wasn't sufficient information until the end of period 2. So the Secretary of State continues the information gathering such as it is. The decision to deport is taken right at the end of period 2. And so what has changed is more information. If we look at the 3 reasons why the deputy judge thinks period 2 is unlawful, what changes in period 3? Reasons. So there's a decision to deport that makes an assessment of offending risk. And we do accept it would be artificial to say, well, that wasn't a detention review. We accept you can read over. So there is an assessment of offending risk. There's sufficient reasons. There's sufficient material. By then, the material's in the Secretary of State's possession. And we accept that the necessity analysis by then has changed because you've got someone... I'm sorry.
But in terms of just take reasons as one of the 3 bases that
Yes.
you've identified, are you saying that if at the outset of all of this a decision had been made to detain this man, but insufficient reasons had been given, then firstly the detention would have been unlawful.
Yes.
But you say then he would have been entitled to substantive damages, even if the reasons had been, well, he's really, really dangerous.
No, my lord, and that was precisely our concession about period 1. So if it will be remembered that on period 1 we said it's unlawful for lack of reasons. The defendant agreed, and we said, but we accept if the only problem were a lack of reasons, that would not give rise to substantial damages.
So the 3 bases of illegality, where you say one is inadequate reasons, that was your second, that doesn't give rise to substantive damages.
Not on its own. I mean, the domestic law equivalent would be someone doing an inadequate detention review or not doing a detention review at all. But you always have to look at what's really going on. Is there justification? And so the deputy judge is saying there isn't justification. There wasn't a justification capable of satisfying the Article 27(2) standards in period 2. That's what he is saying.
But there was at stage 3 because of the decision to deport.
There was at stage 3 because the reasons have changed, the materials changed, and the necessity position has changed because at that point, until the claim for judicial review is issued, you've got a prospect of quite speedily removing someone. The certificate would have meant that he could be removed pending the outcome of pending the hearing of his appeal.
We say that there wasn't justification to detain him. We now know there was. The Secretary of State didn't know that because he hadn't made the right inquiries, hadn't got the right information. It's wrong to say there wasn't justification to detain him because we now know that on the 31st of December, for example, there was an OASIS assessment which says, on the basis of his offending, propensity to reoffend in a violent way. What was missing was it was a procedural breach.
My lord, we say it's not only a procedural breach because what does the Secretary of State have to do on those 3, to put it right, on those 3 bases of illegality? Secretary of State needs to release. If the Secretary of State doesn't have enough information, then the Secretary of State must release. It's pointed specifically in the Secretary.
If the Secretary of State hasn't got sufficient information, what he has to do is give sufficient information. The Secretary of State hasn't given adequate reasons. He has to give adequate reasons. That's right, isn't it?
My Lord, no, we don't accept that, because we say it's not just about, well, can I come back to this point and take you to our second point, which may make it more comprehensible what I'm trying to say? We say that there's a fallacy in the defendant's case of saying, well, all we had to do was get the missing information. Because at paragraph 64 of the judgment, what the deputy judge says is the state can make an informed decision or not impose the restriction. So what the defendant is doing in period 2 is detaining on a basis that's not permissible in EU law. So the counterfactual is, what happens if a defendant acts lawfully? The answer is, either the defendant...
Counterfactual is what if the defendant...
had acted lawfully.
In other words, had gathered the information and acted on it.
Oh, well, there are two subset scenarios, as it were. Either the information is available, Secretary of State goes away, gets it, and says...
We know the pre-sentence report is available because it always is.
I want to come back and say the Secretary of State's whole analysis, of course, is that the overall material that was needed to justify detention and deportation was not reasonably obtainable by him in advance. But suppose it was, then the answer is that the detention would have been shortened. So we say, if...
That's your respondent's notice point that Mr. Anderson did address. Would you like to address first his actual argument on paragraph 64 that there is a conflation of liability, or matters which are relevant to liability and matters which are relevant to quantum? Unless you accept it, of course.
No, we don't, my Lord, and thank you. So, actually, can I just finish the point I was making, just because to avoid having to come back to it? So, and then I will come back to this attack on the deputy judge's reasoning. In the scenario that we were just discussing, habeas corpus application made during period 2, the judge says to the Secretary of State, can you go away and get this information now? Because if not, you're going to have to release this man. And there are two answers to that. Either the Secretary of State can't get the information, or won't get the information, in which case must release, there's not enough justification. Or the Secretary of State says, well, gosh, now I'm going to get a fire under my wheels, I made quickly go and get it, and it was there all along. In which case, we say, the whole period of detention would have been shortened. So we're saying...
Well, that's your respondent's notice,
yes,
I understand.
Yes.
If you're happy to accept the main argument, we'll move on to the respondent's notice.
I beg your pardon. So, we don't accept the criticism of a deputy judge's analysis for the following reason. We say that there is a question of principle and legal policy, not only going to liability, but also going to quantum. Because the dispute between the parties is about what's the right counterfactual. Is it that you assume that the the Secretary of State is able to get the material on the spot, and you put necessity out of your mind, which is essentially what Mr. Anderson is urging the court to do, but that's our response, not just mine. Or is it that you say there was insufficient justification, and therefore the onus of the requirement on the Secretary of State acting lawfully was to release? So there are two counterfactuals. There's a choice, a legal policy choice that confronts the court about what's the hypothetical universe that one's dealing in. And we say, on first principles, and that's what the deputy judge is really addressing there, one takes not only on the question of liability, but also on the question of quantum, the approach that is most protective of individual liberty. And so he is not saying, I think we should have vindicatory damages, there's no loss, and nonetheless, never mind lumber, I'm still going to give this man damages. He's saying there are two ways of understanding the counterfactual here. There are different analyses of loss. And
sorry, the
yes.
counterfactual normally, when there's a breach of a legal obligation, is that the obligation was not breached.
Yes.
Here, the breach of the obligation was the obligation to obtain information and consider it. So the counterfactual is if the information was obtained and considered. That seems to me to be a conventional approach.
My Lord, we say that's certainly Mr. Anderson's argument, which is that there is only one failure, which is the failure to get information. But we say there's the other way of approaching this, which we say is equally valid, and I shall take in a moment to the case of Parker, which we say supports us on this, is that you say, what would have happened if a detainer had appreciated his legal obligations? And the loss, therefore, for the claimant is the Secretary of State's failure to say, I just don't have the reasons or material to justify detaining this man, I must release. So what would have happened had the Secretary of State appreciated his legal obligations? Answer, release. Answer, well, yes, my Lord, but I think it probably is right then that I come on to the respondent's notice point, if I may.
Right.
But I hope I've addressed you on why we say the deputy judge, he's certainly not saying, never mind lumber, never mind causation, I'm going to effectively punish the Secretary of State in this particular case, notwithstanding the absence of loss. He directs himself impeccably on the need for causation, a distinction between substantial and nominal damages. Rather, what he is saying is there is a question of legal policy about where there is a failure at time A to justify detention, you allow the Secretary of State to call in aid information that he only acquired at time B to say that no substantial damages should be available.
Right.
So coming on to my respondent's notice point, so we say there are two scenarios. Either the Secretary of State confronted with a judge saying, where's the information, get it now or release. Either the Secretary of State can get the information or can't. Lord Justice Hickinbottom is saying, my Lord Justice Hickinbottom is saying, can get the information. So what happens then? And we say, we appreciate it's fact sensitive, but in this case, if we look at the facts, there would have been a shortening of the time of detention. Can I come on to that point now?
Yes, is this an argument you made to the judge?
My Lord, I mean, the particular issue of quantum was dealt with quite quickly, I think it's right to say. The question of how the facts worked in period 2 was dealt with in great detail by both parties, I think. So
the answer is no, but because the judge doesn't deal with it, does he? No. But you would say that's perfectly good matter to have in a response notice, yes?
Yes,
yes.
Beautiful, yes. Can I turn now to how the facts work at period 2? Because this is a point that Mr. Anderson makes when he's trying to resist our submission that if the information were available earlier, that would have shortened the detention. So the defendant's answer is to say, well, we had to wait for the claimant's response to our questions on the notice of liability to deport. And there are several problems with that. I mean, stepping back for a moment from the facts of this case, there's obviously no reason why a foreign national who's convicted of an offence should not, as a matter of course, be invited to make representations as to why he or she should not be deported. That doesn't mean the Secretary of State has to consider the representations regardless of sentence. It means that the representations are already available. So there's no reason why that can't happen earlier. If the Secretary of State would no doubt say, well, we have no idea until we see sentence how serious the offence is. And the answer is, well, that would be a legitimate function of the list of serious offences appended to Chapter 55 EIGs, to try and work out from whom do you elicit representations. But the defendant says, well, we couldn't ask people before we knew that they were actively being considered for deportation to make representations. We couldn't ask them early on. And he says it would be too intrusive and unsettling, to which the answer is far less intrusive and unsettling than a period of 1 month's detention. So there's no reason why information could not have been elicited from the claimant after his conviction and before his sentence. And point out in this context that the law is very familiar with the notion that people would be warned before sentencing about the prospect of deportation. There's actually a statutory provision, Section 6.2 of the Immigration Act 1971, that requires that foreign nationals, before sentencing, 7 days before sentencing, get warned that they might be the subject of a court recommendation for deportation. So it's not at all alien or odd to have a notion that you warn people in advance you might be considered for deportation. But even putting that to one side and now coming to the claimant's particular facts, the defendant doesn't start information gathering at all until the 29th of February and doesn't chase it until the 29th of January.
I'm sorry to interrupt. There are all sorts of things which could have happened earlier.
Yes.
But Mr. Anderson says, although slightly more elegantly than this, so what? If this information had come in earlier, we would have made a lawful decision earlier, but a lawful decision to detain earlier. Because the information that would have been gathered would be the behaviour which led to the offence. And once we got the information with regard to the offence, we could lawfully detain.
Well, I think there's two separate points. The point that my Lord Justice Hickinbottom is making, the simple answer is, you get the information earlier, you make the decision to deport earlier, consequently the judicial review is issued earlier. I mean, if we just think about the presumption of regularity, consequently the judicial review is issued earlier, consequently release happens earlier. You simply bring everything forward, unless there's some reason not to do that. And Mr. Anderson's answer to that is he said, well, no, actually, we would still have had to give the claimant 10 working days to make any representations as to why he shouldn't be deported. And it's that proposition I'm answering right now. So at the general level of logic, we say that the general presumption must be that if you bring one event forward, everything moves forward. Mr. Anderson says not so, because we had to give an opportunity to the claimant to make representations. And that's why I was saying, well, that opportunity could actually perfectly well have begun while the claimant was still detained under criminal justice powers in remand custody in between conviction and sentence. And
you can you, give notice of intention to deport or even make a deportation order before sentence?
You could in principle. I think that there's two different questions. The notice of intention, notice of liability to deportation, which is what is ordinarily, and I say ordinarily because it didn't happen here, ordinarily accompanied by a questionnaire. That can certainly happen before sentence. I think to make a deportation order before sentence would be very problematic, the actual order, because you would have to really consider what the judge made of it.
Right, get deportation
yes.
order then, but notice of liability to deportation could be given as soon as he had pleaded guilty.
Yes, yes, my lord. And
well, I mean, and it was given on the 30th of January.
Well, this is actually an important point, which is, so he's given notice of liability to deport, which should have been accompanied by a questionnaire. It wasn't actually in this case.
Should have been accompanied by what?
A questionnaire. And I'm sorry, we're going to have to see more Home Office acronyms and form numbers in a moment. Could you go back to the GCID records? And could you look at page 251? And I'm looking at the penultimate entry. And of course, one always has to look at the date of the bottom, not at the top. So the penultimate entry, somebody called Steve Hart says, ICD 0350 EEA served. And I shall show you in a moment that that's the...
ICD?
Now that I'm afraid I don't know. Maybe try and come back to you on that, because I fear that hazarding a guess may not be the best. But we can tell you that Form 0350 EEA is a questionnaire to elicit representations from someone about why they shouldn't be deported. It's not served on the 30th. So he's told you're liable to deportation, you've got 10 working days to respond. Doesn't get given the questionnaire then, actually. He gets given the questionnaire on the 12th of February. And at the bottom of this page, you can see that it's faxed back. In fact, it's only faxed back on the 15th, and that's also another perplexing delay, because in fact, as we shall see in a moment, we claim it completed it on the 12th of February. So Form ICD 0350 is at 64 of the supplementary bundle. Yes. So, for whatever reasons, and of course here is yet another point on which witness evidence would have been helpful, but for whatever reason, he wasn't given this questionnaire until the 12th of February. So right at the bottom in tiny lettering, one sees ICD 0350 EEA. That's the questionnaire he should have got for the notice of liability to deport. And then the date of that document at page 82 is the 12th of February. So he gets it on the 12th of February, completes it on the same day. For whatever reason, it's only faxed back on the 15th. So there's a 10 working day period for somebody to make submissions as to why they should have been deported. We say no reason why that couldn't have started as soon as he was convicted. And of course, even if it had started on the 27th of January, that would still take us only up to the 10th of February, not up to the 25th. But
if we look at what did happen rather than what could have happened,
yes.
Unless what did happen is a breach of duty.
My lord, I want to make sure that I'm following the point. So there was a breach.
Well, I can see it. If you could say there's a duty on the Secretary of State to serve the questionnaire at the time of the deportation order, and still more, if there was a duty to do it before a sentence immediately after conviction. But that's the first time we've heard. If you are saying there's breaches of duty, that's the first time we've heard of it.
My lord, this is simply my submission again, that there's a strict necessity test and that the state must organise its system in such a way as to avoid unjustified detention. So Mr. Anderson, when we say, look, it wasn't necessary to detain him for this long. If Mr. Anderson were able to say to the judge in a habeas corpus application at period 2, fear not, judge, I'm going to run away and get all this information right now, then we say, well, then the detention wasn't strictly necessary and everything would have been accelerated. Mr. Anderson's answer is no, it wouldn't, because we still needed all the time to consider representations. And we say, not correct, because you could have started that far earlier. So this is a response. So Mr. Anderson's rebuttal of our argument that if you accelerate the information gathering, assuming that's true, that it's possible, then you accelerate everything. He said, no, well, we couldn't have accelerated the decision to deport because we needed to give him time for representations. And we say, well, that could have preceded the sentencing and could have preceded the detention. And it certainly could have preceded the 12th of February, which is the first time he got this questionnaire. I mean, the other point that the Secretary of State says is, well, he asked for more time. And it's true that the claimant, who was unrepresented on the 9th of February, wrote a letter himself, and said, page 62 to 63 of the bond, I won't ask you to turn it up. The claimant, just to correct a point that Mr. Anderson slipped on, doesn't say I want time for the questionnaire, because of course he hasn't got time. He hasn't got a questionnaire. So he's just got a letter that says we want information from you in 10 working days. And he says, I need time for pay slips, and I've got a business plan I want to show you. So he's obviously a bit perplexed about what it is he's being asked for, but he says, I want time for that. But there's no evidence anywhere that that's why the decision to deport took so long. So he doesn't say I need X amount of time. Unsurprisingly, he's at that point unrepresented. So he only gets representation from the 19th of February. So at that point, he writes, having got this notice of liability to deport, no questionnaire, saying I need some more time. Secretary of State, there's no evidence that the Secretary of State got back to him and said, okay, we'll give you until X date. Or, okay, but do be aware this may prolong your detention. So it would be extraordinarily unfair if the Secretary of State could somehow prolong a person's detention, delay a decision to deport, on the basis. Yes, but the bigger point is, of course, there's just no evidence that this happened. Where's the witness evidence?
Is there anything else?
So, sorry, can I just have a moment? I've been. Yes, I did say earlier that I would take you to a case of Parker. There are two particular documents. I wish to take you to a case of Parker and also to a policy which we have been referring to repeatedly in our submissions, but that limits what the Secretary of State could lawfully do on the counterfactual. But let me start with the judgment in Parker, which I had said was helpful to us in terms of explaining how the counterfactual should be defined.
What is the proposition for which you wish to cite it?
The question is always, what would the detainer have done had he appreciated his legal obligations? So Parker.
We know that's the question. Yes. What is Parker authority for?
That proposition.
We don't need authority for that proposition. Lord Justice Hickinbottom has been putting it to you for the last 10 minutes.
Can I just explain it by reference?
I didn't use the word appreciated. I said it was what would the detainer have done had he not breached his obligations, not had he appreciated his obligations.
Yes.
Appreciating his obligations and then deciding not to comply with them.
But, well, it's. Can I explain it by reference first? I think it is helpful if I take you to the case in Parker.
But is that the only proposition which you wish to cite it? Because it's not controversial.
Well, in Parker, maybe I can explain it by reference to the facts, but I think I do need to take you to the judgment. What happened was this. There was a murder that happened in the house of a famous entertainer, and the police had been investigating for some time. There was a chief constable who knew the facts of the case very well, and she was driving along to go and arrest Mr. Parker. She got stuck in traffic. So she telephones and gets another officer to go ahead and arrest Mr. Parker. The other officer doesn't have the requisite state of mind, the requisite reasonable suspicion, in order to justify arrest. So there's liability. The question that arises in Parker is, what's the counterfactual? And there were distinct approaches on the counterfactual. What the Court of Appeal says is what would have happened is that either the correct information would have been communicated or the arrest simply would have waited, wouldn't have happened then. And we say, in applying that rationale here, if you don't have the justification, you either have to get it immediately on the spot, which in Parker would have been possible, in which case we're then into our territory of saying you accelerate all the decision making, there is still causation, or you can't deprive the person of their liberty. You can't in Parker arrest, you can't in our case administratively detain. And I fear I may not be summarising entirely properly the Court of Appeal's reasoning, but there was a careful...
miles away from this case. Not a case of the Secretary of State failing in his obligations at all.
It's a case where the detaining official, in that case the more junior police officer, didn't appreciate what was needed. And
no suggestion that they didn't appreciate what was needed here.
Well, they made.
Went about getting it. I really don't think we're going to be helped by a case which is so far away. And what I asked you was whether there was anything else.
My Lord, yes, and it's this policy that I said I was going to take you to. Can I take you to this? It's in.
What policy is this?
Now, this is a policy that relates. I beg your pardon, I'm just reminded that we've gone past 1 o'clock.
Yes. What are you going to show us?
It's a policy specifically relating to detention under the EEA Regulations 24.1. So it is...
That's the one we've seen already.
My Lord, no, but we cited it in our pleadings, and we are concerned that the defendant has at no time referred the court to it, because this policy limits what the Secretary of State could lawfully have done. So even putting aside all our arguments of logic and principle, the Secretary of State had, at the time of the claimant's detention, still now in fact, a policy in force that said it would not detain before the making of a decision to deport for more than 2 weeks. And
it would not detain before making a decision to deport?
For longer than 2 weeks. Save in exceptional circumstances and save if an extension were granted. But there's no evidence in this case that there were exceptional circumstances or that an extension was ever sought, let alone granted. So
it's a completely new point, is it? That if he had complied with his obligations, he'd also complied with this policy, and your client would have been released within a fortnight.
A fortnight of the 27th of January. And it's not a completely new point, my Lord, it's in our written pleadings. But it's a point...
Does the judge deal with it?
My Lord, no, and it's the Secretary...
So it is a new point.
Oh, I beg your pardon. It's a new point in that sense, but the Secretary of State's policy, who it is, didn't draw anybody's attention to it. So the Secretary of State rightly has taken no objection to us making the point, and we make the point in respect. We would have made it in respect of liability if we'd had to, which we don't. But in respect of the counterfactual universe of what happens if the Secretary of State is acting lawfully, what we would call the Parker question, it must incorporate, and the Secretary of State would comply with this policy, which, save in exceptional circumstances, and I emphasise there is no evidence of that, no witness evidence, and we've made this point some time ago, save in exceptional circumstances, the limit is 15 days for detention under Regulation 24.1. That's the power to detain.
Right. Well, apart from saying we'll allow you to take this new point, but obviously we've got to allow you to argue it, I suppose. 2:15.
All right.